Thank you.
My Lord, my ladies, the States to striking out applications in relation to Mr. Zuma's replying affidavit
Yes.
have become settled. The terms of the settlement
Yes.
are the following. Mr. Zuma consents to orders in terms of paragraphs 1 and 2 of the notice of application to strike out, which is at page 1 of the addendum volume 18. There is no order as to costs. Yes, my Lord.
I confirm that. Thank you, Mr. Chairman.
May it please the Court. With the Court's leave, I will deal with the remaining issues addressed in our heads of argument, except that my learned friend, Mr. Breitenbach, will deal with the chapter on the Thales delay complaint. So he'll do one chapter, but for the rest I'll address all the issues. I'll start with the issues of fact. They are dealt with very extensively in our heads of argument in two chapters. Firstly, the chapter on Mr. Zuma's Stalingrad defense that runs from page 19 to page 33. Secondly, the very extensive chapter on the chronology of the facts that runs from page 50 to page 173. What I propose to do is merely to highlight three issues of fact. The first is Mr. Zuma's Stalingrad defense. The second is the decision to prosecute Mr. Zuma, which was taken first by Mr. Piccoli and Mr. Mshe, and I will focus merely on one aspect of their decision, and that is to point out that there is not a shred of evidence in support of the contention that their decisions were politically motivated, not a shred. The third issue I will address is the deceitful trickery of Thompson or Thales, by which they escaped prosecution with Mr. Shaykh in 2004. And we will submit that the dishonest way in which they escaped prosecution at that time is important, because it then rings hollow for them today to complain that they have not previously been charged and that they are prejudiced by the delay. The delay is a product of their own making and, moreover, their own dishonest misconduct. May I start then with Mr. Zuma's Stalingrad defense? We have listed the milestone dates of Mr. Zuma's Stalingrad defense in a note which we beg leave to hand up. Now, before I get to the note, may I just, for your ease of reference, say the topic of Mr. Zuma's Stalingrad defense is dealt with, as I've said, in the chapter from page 19 of our heads, but also in the chronology from page 50. And in this note, we have listed all the milestones of the Stalingrad defense, and you will see after each entry there is a number in brackets. That is the paragraph number of our heads of argument from which the date has been derived. So that if you wish to know more about any one of those dates, that would be the paragraph in which to find it. And to put this in context, you'll see the Stalingrad defense kicks off on the 10th of October 2005. The background to it, as you know, is in the first place that Mr. Piccoli announced in June 2005 that he had decided to prosecute Mr. Zuma. And then in August 2005, there were the searches pursuant to the search warrants executed on the 18th of August. So that is the background. And then starts what we submit is a consistent pattern of litigation designed ultimately to delay. And we list all the cases by which that was done, and I'll go through them in greater detail. But you'll see at the end of our note that the litigation strategy endured for 13 years and 8 months. That is for almost 14 years, without interruption, except for 1 month. And I'll identify the 1 month when we get to it. But it was consistent pattern of litigation for almost 14 years. And ultimately, consistently unsuccessful. Mr. Zuma lost all of those cases. The litigation was moreover conducted at public expense. We know from the Zuma fees judgment of the High Court that the cost to the taxpayer was something between 16 and 32 million rands. So it was luxurious litigation over almost 14 years, the effect of which was to delay, because all of it was ultimately unsuccessful. If I may deal then with the particular cases, it starts off with the application brought by Mr. Zuma and Mr. Halley to set aside the search warrants for the search of their premises. That litigation started on the 10th of October. It was initially successful in the High Court in February 2006. It failed in the SCA in November 2007, and it was taken to the SCA, to the Constitutional Court, where it was dismissed on the 31st of July 2008. Litigation that ran for 34 months, it's almost 3 years. And you can imagine that for as long as that litigation ran, the state didn't know whether the material seized under the warrants would be available to them in the criminal trial. So they were seriously hampered in their preparation for trial, not knowing.
Sorry, Mr. Chan, was it not within his right to have this dispute?
Oh, yes.
Yes,
Oh,
dealt
yes.
with by
No,
the court.
let me say at the end of the day,
Yes.
I'm going to accept that each one of the cases was competent. It was permissible for him to bring it. But there are two big buts. The first is that if you infer ultimately, as we submit you would, that the purpose of the litigation was to delay, then that is an abuse of the process, and that is not permissible. But even if you don't draw that inference, even if you conclude that it was good faith exercise of his rights, then it still means that it was by the exercise of his rights that the criminal prosecution was delayed, so that it doesn't lie in his mouth to complain about the delay if the cause of the delay is the litigation to which he was always a party.
But on that note, it seems like all his applications in the lower courts were successful. And it was the state that then appealed to the SCA, and then the state would be successful there, and then he would appeal to the Crown Court.
It was often so, my lady.
Yes,
It was
yes.
correct. But it was ultimately always unsuccessful. He failed in the final analysis in every one of those cases. But I'm not going to argue to you that there was no reasonable prospect of success. I also won't argue to you that he didn't have the right to launch those cases. I'm going to accept those propositions. But I'm going to ask you...
But we accept for a moment that he had a right to have those disputes adjudicated
Absolutely.
by the
No,
courts.
absolutely. But don't then complain about the delay brought about by them.
I think that is the point that I wanted to come to, that whilst you might argue that those that litigation was meant to delay, perhaps it should be a factor that is taken into account when the whole delay is considered by us. Not that unless you are going to be able to show that all of that litigation was meant to delay the criminal proceedings.
That would certainly be a second factor. But let me not cloud the first consideration by the second. The first consideration is this. Even assuming that he was fully entitled to run the litigation, even assuming that it was reasonably run, despite the fact that he lost every case at the end of the day, making all of those assumptions in his favor, it still means that it is not open to him to complain today about the delay that it caused. We're not here to seek relief against him. We're not asking you to punish him for his Stalingrad defense. We accept it and we live with it. He is here to ask you to stop his prosecution because of undue delay. And our case is, it doesn't lie in your mouth to complain about undue delay, because your Stalingrad, the effect of your Stalingrad defense.
In the case, in respect of the warrants, what actually triggered the litigation was the state by having the search warrants against him and his attorney.
It is true. And he then chose to litigate, as we accept he
which was within his right to do so. Which was within his right to do so.
Within his right to do so. But it caused a delay of 3 years. And what we say today is, fine, we're happy to live with it, you exercised your rights. But don't now complain about the delay of 3 years, because that delay was of your doing. Reasonably, and even if you did so in good faith and reasonably. So that was the first piece of litigation, was the search warrant application. The second case was his opposition to the NPA's application to the court for a letter of request for assistance from Mauritius. This litigation ran in parallel with the search warrant litigation, so it didn't cause additional delay, but it was a second cause of delay during the same period. You will see that the matter came before the High Court on the 5th of June, and that was when Mr. Kemp, when he was asked, why do you resist the state's attempt to get at the evidence, he gave his Stalingrad explanation. It's you don't understand, my lord, it's not a fight between two champs, it's a burning house to burning house defense. And that was driven to the Constitutional Court. That issue, that litigation, Mr. Zuma lost, and it took 15 months, but as I say, in parallel with the search warrant litigation. Then came Mr. Zuma's Audi application.
So this second delay that you're talking about, it's a neutral factor, because it was running parallel to the first delay.
Yes. So the delay during that period had two causes.
Yes.
Two cases. Then came Mr. Zuma's Audi application. That is the application that first served before His Lordship Mr. Justice Nicholson and then was overturned on appeal by His Lordship Mr. Justice Harms in the SCA. And if I can just point out, as far as the dates are concerned, this litigation started in June 2008. That was just before the end of the other two cases, which ended in July 2008. So there was a month-long overlap between those two cases, but no daylight between the two sets of litigation. That application was run before the High Court. Mr. Zuma succeeded before His Lordship Mr. Justice Nicholson. That judgment was overturned by His Lordship Mr. Justice Harms in the SCA, and it lasted for 7 months.
Mr. Chairman, could I ask on this score, because we heard arguments from the other parties, and that is that there were submissions made, don't discard the Nicholson judgment in its entirety, still rely on some of the aspects that he referred to. But if I understood the heads filed on behalf of the prosecuting authority, And that is to say that, you know, the Nicholson judgment, for all intents and purposes, serves no purpose because Harams dealt almost with it on every procedural level and on every evidentiary level.
Absolutely.
So on a factual basis and on a procedural basis, the SCA had dealt with the application.
Absolutely, milady, and with the greatest of respect, seldom has any of us read a judgment which was so devastating in its criticism of a High Court judgment. So, and at one point, His Lordship, Mr. Justice Haram said, it isn't necessary for me to deal with the following issues, but let me do so, lest it be understood that those findings remain standing. So it was a complete criticism and overturning of the Nicholson judgment. To rely on the Nicholson judgment with respect is wholly unfounded.
So if I understood it correctly, the submissions made in the written heads then is that there should be no reliance placed on the Nicholson judgment. The court should focus on that judgment of Harams, as the study accused would have done.
No, it is absolutely.
So, but there's just one aspect which was mentioned by Mr. Kurtz, which he submitted was not dealt with in the Nicholson judgment. That's Section 22.9.
That's
Section 22.9 of the NPA Act. It seems to be relying heavily on that in his submission.
Yes.
That,
I'm going to deal later expressly with his arguments on the power of the NDPP to take this decision, and I'll deal with that contention then. That litigation, the Audi application, ended in January 2009. There was then a gap of a month, because over the page you'll see a month later, in other words, when the prosecution decision of Mr. Piccoli was reinstated, Mr. Zuma made representations. In February, and then those representations succeeded on the 7th of April 2009 when Mr. Shaykh withdrew the charges. On the same day, the DA application started to have that withdrawal of the charges set aside. And let me say there then followed the spy tapes case, and let me immediately acknowledge that the NPA sided with Mr. Zuma in their opposition to the DA. So I'm not in this instance blaming Mr. Zuma for running the litigation. My client did the same. But at the same time, it was an extraordinary example of delay in effect, whether intended or not. And if you look at...
you would categorize it as a systematic delay. Mm-hmm. Because whilst the NPA sided with Mr. Zuma, but Mr. Zuma fully participated in that application.
Indeed. Milady, let me say I'm not even sure that I can blame the system. The cause of that delay was Mr. Zuma and my client.
Yes.
So
it becomes a neutral factor.
I don't lay it only at the door of Mr. Zuma.
But can I just on that point, was it going to make a difference if, for instance, Mr. Zuma did not participate in the DA NPA proceedings, and he decided to abide the decision of the court?
Well, it's hard to tell what the NPA would then have done.
Yeah.
But assuming that they would have been unaffected by his decision, the difference would have been only in one instance. There was one instance where Mr. Zuma appealed an interlocutory order to the SCA and did so on his own. So that part of it, I think it's a 3-year period, would have been avoided. But for the rest, it would probably not have made a difference. But the same logic works the other way. Even if you say my client shouldn't have opposed that litigation, but if it hadn't done so, Mr. Zuma would still have opposed, and the effect would have been the same. So I don't think that between us and Mr. Zuma, the one can blame the other. We should shoulder that responsibility together. But for purposes of this case, where Mr. Zuma blames the NPA for delay, it is inappropriate for him to blame us for the delay when the two of us together were responsible for the delay.
But
But
I think
Mr. Chengrove, sorry, isn't it triggered by someone employed and who was the acting National Director of Public Prosecution, i.e. Mr. Moshe,
Yeah.
which is the cause of all of these cases that follow for that whole period from 2009 until 2018. See, if I understood the arguments presented to us correctly, is that it's still the national prosecuting authority, whether it was Mr. Abrams at a later stage, whether it was Mr. Moshe, but it is caused, the delay is caused by the NPA.
Milady, let me, absolutely.
Yes.
But my submission is that there is a joint responsibility from the first day to the last. And why I say from the first day is for two reasons. The first is that it was Mr. Zuma who persuaded Mr. Moshe to withdraw the charges. He was
It
in,
wasn't Mr. Zuma. It wasn't Mr. Zuma. It was Mr. Zuma's legal representative.
when I say Mr. Zuma, I mean his son.
Yes.
But it was within his right to make representation.
Yeah.
And-
Yes, indeed.
Yes, it
I'm
was
not suggesting he did so wrongfully.
entitled to do that.
I'm not suggesting he did so
But
wrongfully.
the essence of the question is this. The unlawful decision of Moshe triggered the whole event, which then caused the delay. That's the essence of the question.
It is quite correct. But as I said, I would like to submit that there are two qualifications. The first is that Mr. Zuma can't wash his hands, or Mr. Zuma's side, Maneli, can't wash their hands of responsibility for that decision. It was they who sought it and got it. It doesn't absolve Mr. Moshe. Mr. Moshe exercised his powers, shouldn't have acceded to that request. But by the same token, they cannot disavow responsibility for it. That is what they sought and that is what they got. But in the second place, the mere unlawful decision to withdraw, if it had gone on to review, the review might have taken a few months in the ordinary course. It was the opposition to the review which ultimately strung it out for years and years and years. And in that, Mr. Zuma and the NPA were both full participants. It wasn't as if the one was more or less responsible for that delay than the other. So we submit that both parties share responsibility for the initial delay, and both parties share responsibility for the delay, the additional delay, the delay longer than an unopposed review would have taken, a few months to withdraw that matter.
I still have a problem to understand the shared responsibility in making the person doing the representations as a joint party, collective responsibility in this regard, in your submission. Because it is expected of the National Director of Public Prosecutions to know how to exercise his or her rights, what their powers are in terms of the legislation, and to do so prudently. And if we look, we don't even have to go to the judgment of Judge Nafsa. Here, this process is triggered by a National Director of Public Prosecution, albeit acting, who does not inform the prosecution team, and it seems like a deliberate attempt not to inform the prosecution team just before it gets announced they were informed. I don't quite understand. It doesn't appear to me that one is dealing with this, in the correct manner. And then from there on, it just goes on to the litigation boat for almost 10 years. So isn't that then, in essence, the cause of it? I hear you say, but if they didn't make the representations, this would not have been the outcome. Well, it's expected that representations will be made to any prosecutor, junior prosecutor, every day in matters. And one would expect so much more from the acting National Director of Public Prosecutions in exercising his or her. So can one really say this is a joint responsibility that has to be shared?
Milady, in this sense,
Yes.
Mr. Moshe's decision was unlawful. The SCA has held it to be unlawful. You highlight the unlawful features of it, and that is absolutely accepted. So I'm not suggesting anything otherwise. And the question is not today whether the NPA has any recourse against Mr. Zuma for that decision and its consequences. The NPA has to live with those consequences, and it is satisfied to do so. But we are here today in a case in which Mr. Zuma blames the NPA for delay. And the question is whether on that decision, it lies in the mouth of the Zuma camp to blame the NPA for that decision. And it is to that accusation from the Zuma camp that the NPA camp said, but that is what you asked me to do. How can you blame me now for doing exactly what you asked me to do? True, it was unlawful. And I'm not suggesting you shouldn't have asked me. But you can't blame me for making the order when that is exactly what you asked me to make. So in other words, you got your way. You can't now complain to me for Mr. Mshe's decision to let you have your way. We are at this stage not debating whether that decision should have been made or should not have been made. It shouldn't have been made. Clearly shouldn't have been made. What we are about is whether it is open to Mr. Zuma to complain about the delay brought about by that decision, and we submit that it is not, because it was exactly what he asked for. And if I may emphasize the timeline of that case, then you'll see that this is a case of extraordinary delay. The application was launched on the 7th of April. In May, the DA applied for the record, and they followed an interlocutory dispute about that claim for access to the record, which is absolutely a standard request. But the point taken was that the DA didn't have locus to apply for the record. And that litigation ran from 27 May 2009. The objection was upheld by the High Court in February 2011. The SCA granted the application for the record in March 2012. That's over 34 months. It's almost 3 years to resolve that the first interlocutory dispute. There followed a second interlocutory dispute because Mr. Zuma's side resisted access to the spy tapes and other related materials. The DA again applied for access to those materials. The High Court upheld the DA's application. Mr. Zuma appealed to the SCA, but the SCA dismissed the appeal in August 2014. Again, a 24-month delay, 2 years to resolve the second interlocutory application. That one entirely for Mr. Zuma's account. And then after the two interlocutories had been settled, the High Court upheld the main application in April 2016. Mr. Zuma and the NPA appealed. The appeal came before the SCA on the 14th of September 2017. And the remarkable thing is that on that day, both the NPA and Mr. Zuma capitulated. Capitulated not only on the technical point that the NPA had discovered, capitulated also on the merits. In the judgment of His Lordship Mr. Justice Nafsa, in the spy tapes case, in paragraph 60, he records the following, and I quote, Mr. Kemp, on behalf of Mr. Zuma, accepted that the decision by Mr. Mshe was irrational and that a rational decision needed to be made. So that was after 8.5 years of litigation. Mr. Zuma's side, and my side too, NPA, conceded that the decision had been irrational on the merits. The question then is, how does one explain good faith litigation for 8.5 years if at the end of the line there is a capitulation and a concession that that decision had been irrational? And the court then also held that to have been irrational in its judgment in October 2017. That litigation took 102 months. That's 8.5 years. Just before the SCA judgment was handed down, and because everybody knew what was coming after the hearing on the 14th of September, you will see that Mr. Zuma made a second set of representations in October 2017. Or he asked for an opportunity to make representations in October. He made the representations in January 2018. Mr. Abrams refused them in March 2018. That process took 5 months. And then, as far as the current application is concerned, Mr. Zuma was granted a postponement in April to bring the current application, and it is, of course, still running. So the overall time taken by the litigation is 13 years and 8 months, almost 14 years. We would submit with respect that Mr. Zuma's answer conveyed to this court, an understandable answer and one that I don't contest, is that he's entitled to exercise his rights. But that is not the point today. The question today is it open to Mr. Zuma to blame the NPA for the delay in his prosecution? And we submit with respect that the primary cause of the delay was the protracted litigation by Mr. Zuma over a period of almost 14 years. And whatever the motive for the litigation might have been, its effect was to delay the prosecution. And it is not open then, at the end of that line, for the defense to blame the state for the delay and to ask that the prosecution be stopped by reason of it. Then I turn to the second topic, and that is the decision to prosecute Mr. Zuma and the suggestion that it was politically motivated. We deal with this issue in our heads of argument, where we deal with Mr. Picoli's decision from page 91 in paragraphs 187 to 195, and where we deal with Mr. Mshe's decision from page 124 in paragraphs 259 to 277. And the aspect of their decision to prosecute that I'm going to focus on is the suggestion that their decision was politically motivated. And our submission to you will be, you will know that we get later to a submission that in law it's in any event irrelevant, even if it was politically motivated. But my submission to you now is that there is not a shred of evidence to support that contention, that they were politically motivated. And the starting point is the judgment of His Lordship Mr. Justice Squires in the Shaykh case. Because we submit with respect that after that devastating analysis of the facts and the evidence were delivered, that it was inevitable that the NPA would decide to prosecute Mr. Zuma. It doesn't mean, of course, that Mr. Zuma was guilty, but it does mean that there is a very compelling case against him, case to answer. And it is very hard to imagine that any prosecutor acting in good faith can, in the face of that judgment, decide not to prosecute. So we would submit that that decision to prosecute was an inevitability after the Squire's judgment. In fact, this is also what His Lordship Mr. Justice Harms said in his Audi judgment in the SCA. In that judgment, in paragraph 51, His Lordship said the following. He said, "It is difficult to see how Mr. Picoli could, in the light of the Shaykh judgment, have failed to prosecute Mr. Zuma. And we submit with respect that the starting point is that it was inevitable, and if any prosecutor in the face of that judgment decided not to prosecute, one would certainly have questioned the judgment so exercised.
What the proposition that was advanced by Mrs. Kakane is that if you look at the judgment and you look at what was said by Mr. Nuga, at the time when Mr. Nuga uttered those words, he already had evidence that could have prosecuted Mr. Zuma, you know. But the complaint is that why then should you wait for the Shaykh matter why do you proceed against Mr. Shaykh only and leave me out after having made these utterances on the media and then come back after that judgment and say you want to prosecute me? I think that's where the crux of the problem lies.
My Lord, I'm going to later deal with Mr. Nguka's decision, and I'm going to submit to you that his decision was perfectly legitimate in the circumstances in which it was taken. And to judge his decision today with the benefit of hindsight and the benefit of the outcome of the Shaykh trial is unfair to Mr. Nguka. All of us as lawyers know that it's very easy to be wise after the event and to say, see, you had a good case. But to make that judgment call before the case and before the evidence is led and before the evidence is tested and before the evidence is admitted is a different matter. But I'm going to come to the defense of Mr. Nguka's decision, and I'll deal with it later. For the moment, I'm dealing with Mr. Picoli's decision and whether that was politically motivated or not. Because Mr. Picoli's decision and Mr. Mshe's decision are the decisions which brought us into this prosecution. I understand that Mr. Nguka's decision might be relevant to delay, but it's not relevant to the lawfulness of the prosecution as it stands before you today.
I think it's also relevant to the motive because they say you wanted to test the case against Mr. Shaykh before you prosecute him.
It might be relevant to the motive of Mr. Nguka, but it doesn't tell us anything about the motive of Mr. Picoli and Mr. Mshe. And for the moment, my Lord, that's what I'm dealing with, is the operative decision to prosecute, which is the Picoli and Mshe decisions. And in fact, when one is addressing the Picoli and Mshe decisions, the Nguka decision isn't in itself relevant, except that Mr. Zuma's criticism of Mr. Nguka is relevant when one comes to the assessment of the Picoli decision, because their case is that Mr. Nguka had enough of a case to prosecute, and in fact he was duty-bound to prosecute. Well, if that was so, then a fortiori, when there is a much stronger case, is it lawful and legitimate for Mr. Picoli and Mr. Mshe to
and if you look at the motive, they try to trace it back from Nguka, political motive.
No.
That's why I had to ask you.
No, indeed. But what I'm pointing out is that they apply a double standard when they say that Mr. Nguka was duty-bound to prosecute, but Mr. Picoli and Mr. Mshe didn't take that decision in good faith. If Mr. Nguka was duty-bound to prosecute, then so was Mr. Picoli and Mr. Mshe. And let me also say this about the decisions of Mr. Picoli and Mr. Mshe. You will have noticed that the state played absolute open cards in this case, in that it disclosed all its internal memoranda. It was not obliged to do so. Those memoranda are work product privilege, subject to work product privilege. Memoranda prepared in anticipation of litigation. So they were privileged. But the state decided as a matter of policy to disclose all of those memoranda. So you know of the memoranda put before Mr. Picoli and thereafter Mr. Mshe, in which the prosecution was motivated in each case. So you know what the legitimate grounds were upon which Mr. Piccoli and Mr. Mouchet took those decisions. So it wasn't decisions taken in the air without groundwork, without substance, without reasoning. It was decisions taken on the basis of the squire's judgment and compelling memoranda from the prosecution team motivating those decisions. So what remains of the suggestion of political motives playing any part in the Piccoli shared decisions? Well, there's the spy tapes. That's all there is the spy tapes.
Well, I think in Piccoli's decision, there was a suggestion about the Chile trip, that he might have been influenced in that trip to prosecute.
But there is no more than a suggestion denied by Mr. Piccoli. There's no evidence. My learned friend, in fact, if I remember correctly, specifically disavowed making anything of it. And it's merely, its high water mark is, oh, they were together on a trip. But there is no evidence that there was any, that Mr. Piccoli of all people, and let me say Mr. Piccoli of all people, who have shown himself to be a man of the highest integrity, would have allowed himself to be influenced in that decision at all. What remains is the spy tapes. The spy tapes show that Mr. McCarthy...
Sorry, Mr. Trango. The spy tapes come into effect after Mshe had decided to prosecute. Am I correct in
No,
that?
they overlap. They come at the conversations take place after Mr. Mouchet had decided to prosecute.
That's what I'm saying.
But before that decision
There's a
had been
relationship.
announced.
Before the decision was announced.
Yes.
Yes.
So that it is immediately after the decision had been taken. You'll see from the spy tapes that the people who participate in those conversations proceed from the premise that there is to be a prosecution. And what they then debate is the timing of it, before Polokwane or after Polokwane. So what the tapes show, and this is the high water mark of the case of Mr. Zuma. May I interrupt myself, lady, just apropos of something that you mentioned earlier, my lord. When I speak of Mr. Zuma, I don't mean the man personally.
Yes.
I mean his side.
Yes.
So no, we all understand that he acts with brilliant lawyers who advise him on every step of the way. So the high water mark of the case they can make of the spy tapes is, firstly, my learned friend vividly illustrated that Mr. McCarthy has a foul mouth. Secondly, that he doesn't like Mr. Zuma. Thirdly, that there was an improper discussions with Mr. Nguka about the timing of the prosecution. But that's a high water mark of it. It doesn't go to the integrity of the decision itself, the decision to prosecute. And it is not only we who say so. The SCA has already held that to be so. And Mr. Mshe was the only one who decided otherwise. He decided that it undermined the integrity of the prosecution decision, and it's for that reason that he withdrew the prosecution. That decision has been held to be irrational and has been conceded to be irrational. So it's common cause between all of us that when Mr. Mshe thought that the legitimacy and the lawfulness of the decision was impugned by the spy tapes, that was an irrational conclusion.
But I think the distinction which I think Mr. Mshe failed to make was between the integrity of the investigation.
Between the?
Integrity of the investigation,
yes,
and the integrity of the NPA. Because if you find that there's nothing wrong with it, with the investigation, there's no way that the investigation was illegally tampered with, then obviously that prosecution should stand.
Well, I think, my lord, that the question was whether the decision maker who had taken the decision to prosecute, who was Mr. Mshe, whether he was motivated by political consideration. That
I
was
think
the
he
issue.
concentrated more on the integrity of the NPA, of the institution itself.
Yes.
Yes.
But the question
Yeah.
we're concerned with,
Yes.
whatever his reasoning might be, the question we're concerned with is whether the decision to prosecute was in any way infected by political motives.
Yes, that's the point I'm trying to
And
illustrate.
the
Yes,
SCA
yes, yes.
has pronounced on
Has pronounced on it. Mr. Zuma has conceded on it,
it.
that was an irrational conclusion.
And
So,
in his strive to make a decision that will protect the integrity of the NPA, I am mesmerized by the fact that Mr. Moshe asked before this, is there anything here that I had said? As if whether it was important that his conversations were intercepted by
Yeah.
whomever.
yeah.
And I think this is the thing. His decision, in fact, did exactly the opposite
Yeah.
than protect the integrity of the NPA.
No, indeed, that is so, Malay.
Because it was made in an emotional moment. If I verbatim from the SC.
Yeah, he was very upset about discover the misconduct within the NPA, but it's been held and conceded that it didn't rationally affect the decision to prosecute.
But his own conduct was to not be honest with the prosecution team. In fact,
Yeah.
on two scores, not only did he delay informing them, but right at the onset, he also lied to Mr. Downer as to who is really the reason and the person behind the decision of the timing of the prosecution.
That is so, Malady, but with the greatest of respect, the victim of that misconduct was Mr. Downer and not Mr. Zuma. But that it was wrong, I immediately accept. So that we submit with respect that at the end of the day, there is not a shred of evidence to support the suggestion that the decision to prosecute Mr. Zuma was in any way politically motivated. If there were any such a suggestion, it is in any event roundly contradicted by everybody on the NPA side, so that Plascon Evans should in any event determine any dispute or doubt that there might be on the issue. So that we would submit that the proper approach to this case is on the basis that there was no political motive involved at all in the decision to prosecute Mr. Zuma.
Mr. Trango, I asked this question from Mr. Sikakani about the authentication of the spy tapes, because I must say that it's worrying that conversations are listened to, because people say all sorts of things about people. I might be saying horrible things about my brother and sister here, and then
I'm sure you won't ever mind.
So I asked this question about the judge's certificate, if it was ever obtained, because that was the question that was asked by the SCA, and I believe that the Gauteng bench by Dwaba J and the others was also asked. And his answer was that perhaps that is not so much important now, because Mr. Nguga has conceded to the conversations. Is that how we should approach it?
Well, certainly Mr. Nguga can't complain about an invasion of privacy. It still doesn't make the use of the tapes lawful, because the tapes were made under very strict statutory control. I don't have the facts at my fingertips, but let me just make two submissions on that score. I do know that at the time of the Mshed decision, the NPA, and particularly Mr. Mshed and Mr. Hofmeyer, took steps to have the tapes or some of the tapes declassified. And I can't give you the detail of it, but I remember there was a concerted effort to legitimize their looking at the tapes. And secondly, as far as I know, these tapes have already become a matter of public record, so that whereas it might not have been properly done in the first place, it is not something that I believe should concern this court, because there is no new disclosure of secret material in this litigation. My learned friend points me to what Mr. Nuka says in this regard in the Zuma record at page 4549, where Mr. Nuka, paragraph 97, where Mr. Nuka gave his personal account, recollection of those conversations. Can I turn to the third topic? And that is the deceit of Thompson, or now Thales, by which they escaped prosecution with Mr. Shaykh.
Sorry, Mr. Chairman, before we get to Thales, just going back again on what was raised in argument by Mr. Sikakane about the delays in 2006, when the matter was struck off the roll. Do you have any submissions there?
Yes, indeed, my lady.
Yes.
That was in the middle of the search warrant litigation. At the very time that the state was uncertain whether it was open to them to use the materials seized under the search warrants. And you will see that the history is, because they were uncertain, they initially started using it, asking KPMG or not to use it, and then they instructed KPMG that they could use it. But then Judge Msimang was very critical of their decision to use the material while the fate of the material was still before the courts. And they then took a decision not to use it, so that it is correct that when the state came before His Lordship Mr. Justice Msimang, they were not ready to proceed. But the cause of their inability to proceed was the uncertainty about the status of the material seized under the search warrants. And that material, you will see that that uncertainty persisted, and the NPA decided only when the SCA dismissed the applications did the NPA proceed with their preparation, despite the fact that there was still a Constitutional Court appeal pending. But the NPA was anxious not to miss time, and and said to themselves, well, the SCA has lifted the bar that has existed until now under some of the High Court judgments. It is lawful for us to use the materials. And as luck would have it, the Con Court upheld the SCA judgment. But that was the search warrant litigation was a serious impediment to the state's preparation. And I submit in the circumstances, it cannot be faulted for not being ready at the trial date. They say they would have been ready had had it been open to them to use the seized materials from the outset. As far as the Thompson's deceit is concerned, the story is told in the affidavit of Mr. Nuka, and I'm going to give you a copy of an extract from his affidavit, but just to give you the reference. It is Mr. Nuka's affidavit in the Zuma papers from page 4540 in paragraphs 64 to 85. But may I hand up to you a copy of that extract together with copies of the underlying documents. They are all parts of the record, but we have copied them for ease of reference to follow the story. If I may start, you'll see the first document.
Do you have copies for the other code?
Yeah, we do. We do have copies for everything.
Thank you.
Mostly in ours, but it's all there. The first document then is Mr. Nguka's affidavit, an extract from it, the part that starts at page 4540, where he deals with my decision in April 2004 to
That document that you're reading from, we only have this.
Yes.
It is the first document after the cover page.
This is an extract from it is already in our papers behind us. Yes, it's all just
Okay, sorry, thanks.
That is the extract from Mr. Nguka's affidavit from page 4540 under the heading, My Decision in April 2004 to Withdraw the Prosecution against Thales. And what I'm going to do is just to, I won't read all of it to you, but what I'd like to do is to read parts of it and then to go to the documents to which he refers. And those documents are the documents in the little bundle we handed up to you that follow after the extract from his affidavit. So if I may go to his affidavit, I'll start at page 4541 in paragraph 68, where he says, after discussing the matter with me, Dr. Maduna agreed, let's start early, at 67. In early 2004, Dr. Maduna was contacted by a South African attorney acting for Thales, namely Robert Dryman, then of the firm Thales Rates. Mr. Dryman requested another meeting between South African authorities and representatives of Thales, saying that Thales was now ready to cooperate. After discussing them with me, Dr. Maduna agreed, and a meeting was held at his house in April 2004. In paragraph 69, aside from Mr. Maduna and me, those present were the Thales delegation comprising Mr. Dryman, a director of the local Thales company, Pierre Moynant, the attorney of record of Thales accused in the then pending proceedings, A.J. Suklal, and an in-house lawyer from Thomson's in France, Christine Gourier. Then paragraph 70. During the meeting, Thales delegation said they were willing to cooperate, and as Dr. Maduna and I accepted their bona fides, it was agreed that they would contact my office to discuss the parameters of their cooperation. In April 2004, Mr. McCarthy and I met with Advocate Naidu, who was now acting for Thales, Mr. Dryman and Ms. Gourier. The meeting resulted in an agreement which was recorded in a letter by me to Naidu, delivered to him later the day. In the letter, I confirmed that if Mr. Tetard made an affidavit to the effect that he was the author of the encrypted facts, the NPA would retract 2 warrants of arrest against Mr. Tetard and what I thought were then current subpoenas under Section 28. Now that letter, that's the letter of the 19th, it's a letter of the 19th of April 2004, is the following, there is first the encrypted facts that I'll come to later, but there is then the letter in the Zuma file from page 3655, the letter from Mr. Nguka to Advocate Naidu, where he said, I refer to our confidential and off-the-record discussions. If Mr. Alan Tetard executes an affidavit verifying to the effect that he is the author of the letter marked Annexure A, the National Prosecuting Authority will be prepared to retract the subpoenas and 2 warrants of arrest against him and withdraw the prosecution against accused 11. So that was the agreement described by Mr. Nguka. And then he says in paragraph 772, I should add that the idea was that Mr. Tetard's making of the affidavit would be accepted by the NPA as proof of Thales' bona fides and would lay the basis for further decisions which Thales and consultations with Mr. Tetard aimed at his testifying in the criminal trial, if that became necessary. And then on paragraph 73, on 20 April 2004, Mr. Tetard made an affirming affidavit that he was the author of the encrypted facts. Now that affidavit is the next document. It comes from the Zuma papers at page 3656. It's an affidavit of the 20th of April 2004, and it reads as follows. After introducing himself, he says in paragraph 2, I have examined a copy of the document which is annexed hereto and initialed by me and marked X. That's the handwritten version, the original handwritten version of the encrypted fax. He says, I confirm that I was the author of the said Annexure X. Now, if I will ask you to just page 2 pages back, that is the English translation of that document, which became the encrypted fax. And you will see that what it purports to be, if I can start right at the top, on the left-hand side, just below the little numbers at the top of the page, on the left-hand side, there's the letters A.T., Alain Tatard, who was the author of it. And it's addressed to 2 people, J to J, that's Mr. de Jomeron, who was the CEO of Thomson Africa, and Mr. Perrier, who was of Thomson in Paris. I think Mr. de Jomeron was at that time in Mauritius. And the heading of the fax says, Re Jacob Zuma and Shabir Shaykh. Following our interview held on 30 September 1999 with Shabir Shaykh in Durban, and my conversation held on 10 November 1999 with Mr. Perrier in Paris, I have been able at last to meet Jacob Zuma in Durban on 11th this month. That was in March 2000. On the 11th this month, during a private interview in the presence of Shabir Shaykh. I had asked Shabir Shaykh to obtain from Jacob Zuma a clear confirmation, or failing which an encoded declaration, the code had been defined by me, in order to validate request by Shabir Shaykh at the end of September 1999, which was done by Jacob Zuma in encoded form. May I remind you that the 2 main objectives of the effort requested of Thomson are protection of Thomson during the current investigations and permanent support of Jacob Zuma for the future projects. Amount of 500,000 rand per annum until the first payment of dividend by ADS. So what Mr. Tatar did in his promised affidavit was to confirm that he was the author of the handwritten version of this fax. And we submit with respect that it is absolutely clear in the context in which that affidavit was promised and given, was that this would be the first step to prove his bona fides with a view to further cooperation between Thomson and the prosecution. And the implication of the affidavit was certainly meant to be that he confirmed the authenticity of the draft fax. And that is also how the affidavit we submit was meant to say, and what it did convey to the NPA, that at last now we have confirmation of the authenticity of that draft. Now, if you look at Mr. Mluka's chronology, picked up from there, he said, on 4 May, I wrote to Advocate Naidu thanking him for the copy of the affidavit. That letter to Mr. Naidu is the next document in the bundle. It comes from the Zuma papers, page 3657. It's a letter of the 4th of May 2004, where he says, thank you for the affidavit by Mr. Tatar, in which he confirms he is the author of the note in question. In the result, we will withdraw the charges against the accused number 11 in the matter of S.V. Shaykh. We have also instructed the investigating team to withdraw subpoenas and warrants against Mr. Tatar. As regards your request for access to information, the prosecuting advocates will provide you with relevant information to assess you to assist you in further consultation. The said access will be facilitated on the understanding that Mr. Tattard will submit to questioning by the prosecuting advocates and will be prepared to testify at the criminal trial should it become necessary. The letter bears out Mr. Nuka's account that this was the first step towards further greater cooperation between the NPA and Thales, and was so understood. And then follows an important event. If you go to paragraph 75 of Mr. Nuka's affidavit.
Sorry, Mr. Chamber, before we get to paragraph 75, I know you've indicated to my brother early on we get to Nguka, and I take it that we are now here with the decisions taken. If I look at the content of this affidavit, and it starts off here by 68 onwards, and particularly paragraph 70, then it appears that the previous Minister of Justice was part of the decision making as to whether Thompson's at bona fides, and that was a decision that was taken regarding the withdrawal of the charge. And you would remember that submissions were made that politicians were involved in decision making of the National Prosecuting Authority where they ought not to have been. Now, if we look at paragraph 70, does that not fuel those submissions and those inferences?
Yes, my lady, it does. Just subject to one reservation that I'd like to take instructions on, and that's this, that I do understand that there were government-to-government communications about this case, which is a legitimate role of government to liaise with its counterparts at a political level about the case. It's not proper for them then to interfere improperly in prosecution decisions, but that government had a role to play, I understand to be so. But can I come back to you on the detail of it, because I'm not sure of it. Can I go back to Mr. Nguka's affidavit, where he says that he wrote to Mr. Naidu. Oh, what I want to say about his letter to Mr. Naidu, it bears out Mr. Nguka's version, Mr. Nguka's understanding that this affidavit of Mr. Tattard was to be the first step by which he proved his good faith with a view to greater cooperation between the Thales witnesses on the one hand and the prosecution on the other. And it was understood that Mr. Tattard would, for instance, make himself available for interviews by the state and would, if necessary, give evidence in the case. And then at paragraph 75, he says, the warrants for Mr. Tattard's arrest were cancelled on 17 May 2004. That was pursuant to the affidavit. And then paragraph 76, on 10 May, however, Mr. Tattard made a further affidavit which had not been solicited by the South African authorities. The NPA received it on 22 May. So the sequence of events was that there's the affidavit, the warrants are withdrawn on the 17th of May, and then 5 days later, the NPA received unsolicited a further affidavit. And I'm going to go to the affidavit now, but in paragraph 77, Mr. Nguka says, the prosecuting team and I regarded the main assertions in this affidavit about the encrypted facts as untruthful and its unsolicited and unheralded production as a cynical maneuver aimed at disrupting the prosecution in the Shaykh trial and discrediting the encrypted facts. The Tattard affidavit, the second affidavit, is the next document in the bundle. It comes from the Zuma papers at page 3659. It's an affidavit dated the 10th of May, but as Mr. Nguka said, they only received it on the 22nd of May, where he says the following. If I may just read extracts to it. In paragraph 2, he refers to his earlier affidavit. Paragraph 3, I've been informed that the state in the prosecution of the case of Shaykh is seeking to rely on Annexure X as evidence against Mr. Shaykh. That is his affidavit confirming the encrypted facts. I have further been informed that the state intends to use Annexure X to prove various things. And then over the page in paragraph 6, in response to the above information, I wish to state, and then he contradicts every possible inference that one might draw from the facts. And he does so in tabular form, one by one, disavowing every possible inference. And then he said, over the page at 3661, it will be noticed that it is, in sub 4, big Roman 4, the document Annexure X was never, to my knowledge, on my understanding, typed or faxed. It will be noticed that it is haphazard and carelessly drafted with something and amendments, alterations and amendments. It was merely a rough draft of a document in which I intended to record my thoughts on separate issues in a manner which was not only disjointed but also lacked circumspection. It was for this reason that I did not give this document or direct that it be faxed. I crumpled it and threw it into the waste paper basket from where it was possibly retrieved and provided to the state. So a complete negation of his earlier affidavit, and we submit with respect that the two affidavits can't both be true. They contradict one another because the first clearly gives the impression, was designed to give the impression, that he was the author of the draft of the encrypted facts. And what he did in the second was to rubbish that document and to destroy whatever evidential value it might have had. After he had so reneged on the understanding, Mr. Muka said there was further correspondence. If I may just pick it up at page 4544 in paragraph 79, in the second half of that paragraph. In the letter, I nevertheless offered that if Mr. Tattard submitted to an interview by advocates Steinberg and Downer of the prosecution team, the record of the interview would not be used against Mr. Tattard in any criminal proceedings, and I would ensure that the letter of request was withdrawn forthwith. Paragraph 81. On 1 July, Mr. Deplali, that's the attorney, wrote to me again, refusing my offer in his letter of 8 June. In other words, Mr. Tattard now refuses even to be interviewed. Paragraph 82. On receipt of the letter, I and others of the NPA involved with this matter concluded that Thales was negotiating in bad faith and no good purpose would be served by pursuing the negotiations. Despite reaching this conclusion, we resolved to honor the agreement that I had concluded with Advocate Naidu, i.e. to withdraw the charges against Tint when the Shaykh trial commenced. Aside from the fact that I had agreed to do so, there were pragmatic factors which led to the NPA sticking to the original agreement, despite Thales' conduct in the intervening period. These included that Shaykh and his related companies, practically speaking, were the main focus of the prosecution at that stage. French law did not permit Mr. Tattard, as a French citizen who had fled and remained in France, to be extradited to South Africa to stand trial, and the prosecution team was concerned about the trial being delayed by possible arguments by Tint to the effect that its joinder as an accused was a misjoinder, and Mr. Shaykh, who was a director of Tint, should not be its nominal representative in terms of Section 352. And then there was a third Tattard affidavit, which is the next document in the bundle I gave you. And if I may just refer to that affidavit as well. It is an affidavit which comes from the Thales papers at page 101. And it is an affidavit deposed to on the 11th of March 2009. So this is now some years later. And he speaks of his earlier affidavits at page 108 in paragraph 19. At the end of paragraph 19, he refers to his, I deposed to an affidavit wherein I confirmed that I was the author of a handwritten note which later became commonly known as the encrypted fax. And he said in paragraph 22 that he had agreed to the required affidavit as I believed it would bring an end to the matter. So it was done in order to persuade the NPA to withdraw the prosecution against them. I explained to one of the lawyers, Advocate Naidu, in the presence of Dryman, Moino, Gurrier, and AJ, the circumstances which led to the creation of the handwritten note, as well as the fact that subsequent to writing the note, I crumpled it up and threw it in the waste paper box. So he would have it. Now, I'm not suggesting for one moment you should believe any word this man says. But what he says is that in the presence of his clients, his colleagues and his lawyers, he explained to them that, yes, I wrote that note, but it was a informal note of my own ramblings, and I crumpled it up and I threw it away. And despite that account, they file an affidavit which says, I confirm that I am the author of the draft of the encrypted fax. And then he says, I was told that the NDPP had, that he simply wanted an admission of my authorship in exchange for bringing, suggesting that all concerned agree and participate in this dishonest charade of a confirmation of the authenticity of a note which he says, in truth, was crumpled and thrown away. Paragraph 25. I was not satisfied with such a simplistic approach. For simplistic, read dishonest. I was not satisfied with such a simplistic approach, but as this affidavit was required to put the matter to rest, I was prepared to depose to it in the terms requested. I later learnt that a written undertaking was received from the NDPP confirming that the warrant of arrest and the charges against the third accused would be withdrawn in due course. I subsequently became increasingly concerned regarding the terseness, again for terseness read dishonest, he later admits it, the terseness of the affidavit, and I feared that it could be misconstrued. And then paragraph 27, at a second meeting in Paris on 10 May with Naidu, Suklal, Gurrier and Moino, at this meeting I complained bitterly about the first affidavit and told those present that the affidavit was wholly misleading. So he concedes on his own account that the affidavit creates a false impression in the absence of an explanation. And he then says he purported, for the sake of honesty, for the sake of clarity, he then tendered the second affidavit. But what we now know is that the second affidavit was a tissue of lies from beginning to end. And if I may take you on that score, firstly, to Mr. Downer's affidavit, which is the next document in the bundle, in that little pack. It's Mr. Downer's answer in the Zuma papers at page 2766, paragraph 184, where he says the following. I would add that the NPA has always regarded the main assertions in this affidavit about the encrypted facts as untruthful and its unsolicited and unheralded production as a cynical maneuver aimed at disrupting the prosecution in the Shaykh trial and discrediting the encrypted facts. The evidence in the Shaykh trial proved conclusively that Tattard was lying in this affidavit about the encrypted facts. Forensic evidence showed that the handwritten version was never crumpled up and was indeed typed and printed on 17 March 2000. The evidence of Tattard's secretary, Sue DeLeek, that the typed version was faxed to Paris was accepted. Can I just interrupt myself for the moment? My learned friend said yesterday my learned friend for Thales, said that there are 4 people who can tell us what happened, and all of them are unavailable. He doesn't include Sue Deleek, the woman who typed the fax, and she is still alive and well and living in South Africa. But it goes on. Sue Deleek testified that the typed version was faxed to Paris and was accepted. It was corroborated by Telkom records, which showed that shortly after 17 March 2000, faxes were sent to France from the offices of Thomson. A French language expert testified that the form of the letter conformed in principle to principles of French business correspondence, thereby refuting Petard's claim that the letter was disjointed or lacked circumspection. Every material fact mentioned in the fax, persons, dates, and events, were corroborated by other evidence. And lastly, my lord, my ladies, that was also so found by the SCA. The last document in the bundle is the SCA judgment in the Shaykh criminal appeal, or extracts from that judgment. And if I may be allowed just to read a few of those paragraphs. Paragraph 40, in respect of the main charge on count 3, the court below had regard to the evidential foundation, which is the handwritten draft and the actual encrypted fax. It was not disputed that the draft message was written by Tetard, nor was it disputed that at the time Tetard and Shaykh were directors at Thomson's. The court accepted the plain and obvious meaning of the fax, that a proposed arrangement discussed at 2 previous meetings by Shaykh and Tetard on 30 September 1999 in Durban, and by Tetard and Perrier on 10 November 1999 in Paris, respectively, was confirmed at a 3rd meeting in Durban on 11 March 2000, involving Shaykh, Tetard, and Zuma. And agreement was reached on that proposal. It was also accepted that a draft of the fax was composed to be sent in encrypted form. Tetard's 2 superiors in Paris, including Perrier, what was in dispute was the nature of the proposal. And then the fax is quoted in paragraph 166 and 167. It is common cause that Tetard was the author of the fax. On the face of it, and it interprets the facts, the court below concluded that there was no doubt that the encrypted facts reported the conclusion of an agreement. And 203, the facts, the correspondence, and Shaykh's false evidence, the service provider agreement, and the payment terms thereof, cumulatively, in our view, fully justified the finding of the court below that it had been proved beyond reasonable doubt that what Shaykh described as a request for a donation to the Jacob Zuma Education Trust was in fact a request for the payment of a bribe. Now, I'm not, of course, suggesting that Mr. Zuma is guilty, but what I am suggesting is that it is absolutely clear that Thomson's, Thales, escaped prosecution by dishonest trickery. Mr. Tetard's versions, one after the other, were contradictory. The only honest affidavit he ever made was the literal statement in the first affidavit that he was the author of the document. But it was also designed to create the impression that he confirmed the authenticity of the document. That, he says, was dishonest, but that contradiction of it was later held to be a lie in any event.
Mr. Trengrove, just to get back to the submissions that were made by Mr. Katz regarding the undue delay, at a very early stage, it was known to the prosecuting authority that there had been a dishonest, that Mr. Tetard was dishonest. In fact, there were 2 affidavits under oath that contradicts each other, and again, that constitutes also a criminal offense. Yet, it delayed the prosecution then for some time. Now, I understood the affidavits filed here that there was the one exercise was the practicality of not charging then Thomson CF with Mr. Shaykh because of the anticipated challenges. But then, why wait until 2006 only to charge when clearly there was dishonest behavior on their side?
Well, there are two parts to it.
Yes.
Why didn't they persist with the prosecution with Mr. Shaykh? Mr. Muka explains in that one paragraph I read to you, he said that was so for various reasons. One of them was that we were afraid that he would challenge our right to restart the prosecution, and whatever the outcome of that challenge, it would delay the Shaykh trial. We didn't want to delay the Shaykh trial. The second was that even if there was no such challenge, it would have delayed the Shaykh trial, and we wanted to avoid that delay. But let me say about that, it is one thing to be critical of Mr. Nguga's decision to stick to his undertaking when it might have been open to him to go back on his undertaking because God had gone back on his undertaking. But again, we are here debating who is to blame for that delay. It doesn't lie in the mouth of Thales to say, you shouldn't have honored your undertaking because I breached my undertaking and it was therefore open to you to breach your undertaking as well. That surely is not an argument that could ethically or morally be advanced to blame the NPA for delay, for not reneging on its undertaking, because Thales had reneged on theirs. So we submit for two reasons. Mr. Nuka's reasons, Mr. Nuka gives his reasons. They are practical, logistical reasons for not seeking to reintroduce that prosecution. But even if we don't agree with him, it doesn't lie in the mouth of Thompson, having lied their way out of the prosecution, to suggest we should have prosecuted nonetheless because we had caught them out in their lie. Could I turn to a different topic? And that is the topics we address in our heads of argument from page 10. Where we deal with what we call a few basic principles. And our submissions really speak for themselves. I'm not going to repeat them, but I would like to highlight a few of them. We start off with our submissions on the seriousness of the crime of corruption and the state's duty to prosecute corruption, which is recognized both at international law, in the Constitution, and in the Prevention and Combating of Corrupt Activities Act. And our learned friend, Mr. Sekikani, said it's not necessary for us to lecture them on the seriousness of corruption. And we're sure that that is so. We didn't intend to lecture them. We're making these submissions to the court. And let me just explain why. The courts have said that when an application is made for a stay of prosecution, on the one hand, one side of the scale, there is, of course, the accused's right to a fair trial. But there is an important consideration on the other side of that scale as well, and that is the public interest in ensuring that crime is prosecuted. And in that context, the nature of the crime is very important, because the more serious the crime is, the greater the public interest in ensuring that it is prosecuted. So that it is important to understand in this case how serious the accusation is that is made against Mr. Zuma. As matters stand at the moment, he is accused in the first place of corruption, which is corruption by an abuse of his power for profit. He is accused in the second place of racketeering, which is large-scale corruption, in the sense that it was run in collaboration with others in order to make a profit. In the third place, money laundering, which is the concealment of the proceeds of crime. Now, those are very, very serious crimes. They are alleged to have been committed by a very powerful public official. There is, in the circumstances, a very high public interest in ensuring that this crime is prosecuted, because not only the usual considerations are at play, vesting a high public interest in the prosecution of all crime, but there is also a significant rule of law consideration in issue, and that is this. Fundamental to the rule of law is the principle that everybody is equal before the law and that everybody is treated equally. And it is very important, therefore, that when a very powerful public official is accused of very serious crime, that he be seen to be treated as everybody else is, and that he does not receive special treatment because of the importance and the office and the power that he holds. So for that reason, the nature of the crime in this case is always an important consideration in a stay application. In this case, it's a very powerful consideration. We deal from page 12 with the right to a fair trial, and it is common cause between us what an important right it is. We just wish to emphasize, as we do in our heads of argument, page 13 from paragraph 17, that our courts, the Constitutional Court, has repeatedly made it clear that the right to a fair trial is not a one-sided right. It is also a right that requires fairness not only to the accused but also to the public represented by the state. And that is not only always so.
Please don't take pictures. Don't use your cameras in court. If you want to do that, please go outside and use them outside, not inside the courtroom.
That is not only always so. The Supreme Court of Appeal held in Zanner. No problem. We say it in our paragraph 18. We note that the Supreme Court of Appeal held in Zanner that in a stay application, it is an important consideration to bear in mind that in a stay application, a balance has to be struck between the protection of the accused on the one hand and the protection of the public interest in ensuring prosecution of serious crime on the other. And therefore, that principle operates all the more so where the crime is as serious as the one contended for in this case. And then two trite propositions. At page 15, we submit that a litigant's case must be based on facts. And at page 16, that motion proceedings are confined to common cause facts. Now, those propositions are obviously trite. Our learned friends obviously pay lip service to them, but we submit they only pay lip service to them because what they do is, despite those principles, still argue before you on the probabilities of the facts. And we just submit that whenever you come to a debate on the probabilities of the facts, it is assured.
It's one of the points which was raised by Judge Haramse in that.
Indeed, absolutely.
That's why he also missed the mark.
All these arguments that we heard, political conspiracy is one of them. But all these arguments which debate the probabilities are completely out of place. Because it's a fatally flawed argument for two reasons. Firstly, there's no evidence underpinning it, and we've already pointed to that. But secondly, in motion proceedings, the facts put forward by the respondents are accepted as true, and there's no room for a debate of probability. And then a third proposition, which is as trite by now, at page 17, we say that the motive behind a prosecution is irrelevant. Our learned friends again accept it, but we pay lip service to it, because what it says, and the principle was not, established, but the principle was recognized by Justice Harms in the Audi case and was repeated by Justice Nafsa in the spy tapes case, that the motives behind the prosecution are irrelevant. It doesn't matter what the motive is. An impure motive, a political motive, doesn't render a prosecution unlawful if there is just cause for it. So the only inquiry is whether there is just cause for the prosecution. And let me again make the point that His Lordship presiding made earlier on. Their case is that there was just cause on day one when Mr. Nguka decided to prosecute Mr. Shaykh. Now, if there was just cause to prosecute Mr. Zuma then that case only became stronger over time. So it is common cause on everybody's understanding of the facts that there was just cause for the prosecution of Mr. Zuma. The debate...
But do they say there was just cause? They say that's what Mr. Nguka said.
I forget what they say.
They say that is what Mr. Nguka said, not that they admit that there's just cause.
Well, I understood them to accept his characterization of a prima facie case, and they then say that because there was a prima facie case, he had a duty to prosecute. We don't accept their test for prosecution.
I think you take issue with the test because there's also reliance placed as to whether the state, again, we get back to the prosecutorial discretion. Does the state institute prosecution when they have a prima facie case, or do they institute prosecution when they have a prima facie case and there are reasonable prospects of success of a conviction?
No, your lady is quite correct. And let me say, we're going to submit, and we submit that it's obvious, that the question is not whether you have a prima facie case in the sense that you have evidence which, if true, will establish an offence. The test is whether you have a case with a reasonable prospect of conviction. That is the test laid down by the prosecution policy. And all I'm pointing to is a contradiction in their case, in that they say Zuma had a duty to prosecute, suggesting that whatever the test for prosecution was met at that early date. If that is so, then they must accept that there was just cause for prosecution at every stage thereafter. And if that is the only question by which the lawfulness of the prosecution is tested, well, then it's common cause. But perhaps it's being too tricky for me to want to draw that analogy. All I need to say is that after the Squire's judgment, there can't be any debate about a just cause for prosecution, and there is no debate for it. There is a debate about political motives, but that debate is irrelevant in the light of this principle. I may turn then to an entirely new topic, and that is Mr. Zuma's core complaints.
Can you just take it action?
Thank you, my lord.
We'll come back to that. see, before you carry on, they complain about taking pictures, photos in the courtroom seem to persist. And I hope whoever is doing this, that please restrain yourself, because that is not allowed within the courtroom.
Thank you, Madam. Well, may I come back to two issues touched on before tea? The one was my statement that Ms. Sue DeLeek, the secretary who typed the fax, is alive and well and living in Pretoria. That was, in fact, our information before tea time when I made those statements. I got a message over tea time from a stranger to say, via my secretary, to say that she has in fact passed away. Colonel Deploy then went to follow up on that information and confirmed that that was so. So it does appear that Ms. Sue DeLeek is no longer alive.
Last night. Last night. She died last night.
Yeah.
Last night.
No. The other question is the question raised, Milady, about the role of Dr. Maduna. And may I ask you please to go back to the extract from Mr. Nguka's affidavit that was included in that little bundle. Because I'm told that that does accurately describe his role, and I just want to point to what it was. The background is that Thales is owned by the French government, so it is a government company. Against that background, you'll see in the Nguka affidavit at page 4540 in paragraph 64 that the interaction between the parties started as follows. In the latter half of 2003, an intermediary acting for the Thales group contacted Dr. Maduna saying that Thales wanted to meet with him and me because they were ready to furnish the NPA with information. And then 65, pursuant to this approach, Mr. McCarthy and I, that's Nguka, traveled to Paris. So that was the first approach. The approach was made by Thales, but Dr. Maduna did no more than to pass on the message to the prosecutors, who then traveled to France to meet with Thales. That was the first contact. Then over the page in 4541, in early 2004, Dr. Maduna was contacted by a South African attorney acting for Thales, namely Robert Dryman. Mr. Dryman requested another meeting. 68, the meeting was held at Dr. Maduna's house in April 2004. And then 69 describes the parties present at the meeting. 70, during the meeting, the Thales delegation said that they were willing to cooperate, and as Dr. Maduna and I accept their bona fides, it was agreed that they would contact my office to discuss the parameters of their cooperation. So that meeting is merely, again, Dr. Maduna gets approached, he holds a meeting and he puts the French in contact with the prosecution.
Mr. Stringer, you can assume in my favor I've read the Bulelani Nguka's affidavit from cover to cover. What concerned me is that if you go back to paragraph 67, you see, it was quite right that Dr. Maduna referred them to the prosecuting authority. When an attorney decides to then call a minister or request a minister to meet, that should have been the same approach. Please contact the National Prosecuting Authority, the National Director. In terms of Section 35, they only sent me their reports. And that's really what I was concerned about, because 70 appeared to be that during that discussions and that time, there was someone. And that is exactly when we look at the affidavit filed by Mr. Piccoli, which he was criticized for by saying that he did not inform the previous minister, Mabandla, sufficiently. He very much insisted that the only kind of information he shares is not regarding the institution of prosecution or the withdrawal of matters or when and how, but it's simply a report, and that is his duties in terms of Section 30.
Ms. Lady, I accept that proposition. All I'm submitting is that, whether rightly or wrongly, Dr. Maduna's role never went beyond merely introducing the one side to the other, and he never participated in any of the decision-making on the prosecution side. Because you'll see that after that meeting, there was an indication in principle that they would cooperate, but the outcome of the meeting is that they would speak to the prosecutors, which they then did, as is described in paragraph 71. May I then turn to our heads of argument at page 174, where I deal with what we call Mr. Zuma's core complaints, notably about the Nguka decision, the Bukoli decision, the Mshed decision, and then the Browse-Mole reports. I've already dealt with one aspect of those decisions, and that's to say that there's no evidence to suggest that the Bukoli decision or the Mshed decision were politically motivated at all. But let me just deal with the three decisions, each individually, starting with the decision of Mr. Nguka. Now, there is a first question, and that question is, why did he decide to prosecute Mr. Shaykh, but not Mr. Nguka? Not Mr. Zuma. And we deal at page 175 with Mr. Nguka's explanation for it. And the gist of the explanation is this, that he had a recommendation from the prosecution team to prosecute Mr. Zuma. But he assembled an advisory team of 8 senior prosecutors to advise him on whether he should do so or not. And the advisory team concluded that there wasn't a sufficiently strong case against Mr. Zuma to warrant a prosecution. So at the end of the day, there was a difference between the two groups of lawyers, the prosecution team and the advisory team. And with the greatest of respect, there is no point today in debating who was right or wrong. We all know that when lawyers look forward to a case which they haven't yet run, that they often have differences of opinion on their prospects of success. And here were two groups of lawyers with different opinions. Mr. Dawa thought then there should be a prosecution, and he says today, I still think so, and I believe that the Nguka decision was wrong. But Mr. Nguka acted on the advice of 8 other senior lawyers who felt otherwise. In fact, Mr. Sikakani referred to the affidavit of Ms. Davids, her memorandum, at page 1957, and more particularly 1962, where she expresses the view, a very negative view, on the prospects of success. So my learned friend Mr. Sikakani says, and I quote him, they, the NPA, they knew they were skating on thin ice because Ms. Davids had warned them so. Well, with the greatest of respect, it's not a question of skating on thin ice. It means that there is another credible view of integrity, that their prospects of success are poor. And Mr. Nguka had to decide between these various groups and the advice they gave him, which way to go. And Mr. Nguka decided, was persuaded by the David's group, by the senior advisors, that they didn't have a sufficiently strong case to warrant a prosecution.
Sorry, Mr. Chengo. I think that was part of the criticism, that it was extraordinary for him to have sought another view, yet the investigative team had recommended otherwise. What is your comment on that?
No, I submit that it is a very wise precaution, because one knows that the prosecution teams, not this one, I would never insult Mr. Downer, but the prosecutor in the case often has a bias in favor of prosecution, because it is his case and he's persuaded himself that he's right. I know that lawyers sometimes persuade themselves that they have a strong case when that is often not so. So what Mr. Nguka said is, I wanted a balanced view from those driving the case and from those looking at it cold. And he got a balanced view from it. And it is not appropriate to ask who's right and who's wrong. The question is, was that a good faith and rational decision in the circumstances? And we submit that it was.
Right, Mr. Tringgrove, isn't it that Mr. Nuka went further and he sought advice from someone outside? And that was the other submission
Yes.
that was made to us, that was extraordinary in seeking the input from a advocate, a senior advocate.
I understand.
Now that is unusual because the prosecutors decide on their own matters, and there is a wealth of intellect in their own circle to deal with this. To now go and get someone on the outside, and with the greatest respect, I have great respect for Advocate Morani. He appears many times before us, so it's not about the individual. I'm merely dealing with someone outside the prosecution service. Is that not extraordinary? Because seemingly when one considers bad faith, it is suggested, and I know what Mr. Nuka says, it suggested that should not have happened. There's of course something else that has been said, that this was someone that also has a relation to an previous president of the country, President Mbeki. But there was someone on the outside that was.
As I understand, Mr. Nuka, he didn't go to the advocate to ask him what to do. He went to the advocate with a conclusion and a sanity check, as it were. He said, "This is my conclusion. Tell me, do you think I'm right?" And there was the issue on which I understood him to be particularly interested in getting an outside view is whether it was rationally sound to conclude that although there is a prima facie case, I have decided not to prosecute. I have decided not to prosecute because the prospects of success are poor. And Malady, let me say, it is certainly unusual in the sense that that's not the ordinary way in which prosecutors might take their decision. But it is not uncommon either. It is a very frequent occurrence that prosecutors take outside advice on the question whether their decisions are right or wrong or appropriate or not. So I would suggest that far from detracting from the credibility and integrity of his decision, it adds to the credibility of it. He took an extra precaution to make sure that he got it right. And there can't ever be a suggestion that for an NDPP, not only to take inside advice, but also to take outside advice is somehow impermissible. It is a commendable additional precaution that he took. So we submit with respect that the decision not to prosecute is one that we can debate and differ from or agree with, but it isn't rendered unlawful simply because we, with the benefit of hindsight, suggest that he should have decided otherwise. But the other aspect of his announcement of that decision is that he is criticized for announcing that he's decided not to prosecute despite there being a prima facie case. But he explains it as follows. He says, and remember the circumstances, that's 2003. The NPA is a young and untested organization. Its integrity and its political will to strictly adhere to the principles of its office are as yet untested, and the public are watching them with hawk's eyes. And he comes up with an announcement that there were two parties to a crime, but he's decided to prosecute the one and not the other. And what's more, he's decided to prosecute the common man and not the deputy president. The implication that if there's a case against the one, there must also be a case against the other. You can't have a case against Shaykh and not against Zuma, if the case is one of bribery. And he knew that that connection between the two would soon be revealed in the indictment that would become public within days. Now, in those circumstances, it is important for him to explain to the public why it is that they've decided to prosecute the common man and not the deputy president. And to give that explanation, to persuade the public that it doesn't mean that the NPA favors powerful people at the expense of ordinary people, that that distinction had nothing to do with the difference in status of the two people. So that statement was made in defense of the integrity of the NPA. Again, one can differ from him on the wisdom of that explanation. But what is quite apparent is that it was an understandable and a good faith explanation to defend the integrity of the NPA against the risk of it being thought to buckle in the face of power, but prosecute a common man. It is lastly said that the decision not to prosecute Mr. Zuma is in breach of the prosecution policy, because it said that the prosecution policy requires prosecution whenever there's a prima facie case. And Milady, you've made the point in that, so that the prosecution policy says reasonable prospects of conviction is the test. And in fact, in the Harm's judgment, His Lordship defended the decision on exactly that basis, drew the distinction between a mere prima facie case, i.e. evidence which, if true, would prove an offence, and evidence which establishes a reasonable prospect of conviction. And it's the latter that is the test and not the former. Mr. Zuma lastly complains that he should have been charged with Mr. Shaykh because he would then have had the advantage of cross-examining Mr. Shaykh when he gave evidence. Now, on that score, may I make 3 submissions? The first is one doesn't know what Mr. Shaykh would have done if there was a joint prosecution and he was exposed to the cross-examination of Mr. Zuma. So one can't assume that he would have given evidence as he did.
Well, isn't the case in point exactly what happened in the Busak matter, where Mr. Busak elected not to testify?
No, exactly.
And so it can never be predicted what any person will
Indeed,
do.
milady. And then in the second place, if they had been prosecuted together and Mr. Shaykh decided not to give evidence, he would also not have been a compellable witness at the instance of Mr. Zuma. Whereas if he's prosecuted alone, he can compel Mr. Shaykh to give evidence, or he can persuade the court to call Mr. Shaykh for cross-examination. So that there's no reason to think that he's worse off today than he would have been then. But in the third place, the constitutional, Mr. Shaykh raised exactly the same complaint. He said, I should have been prosecuted with Mr. Zuma because I would have then had various advantages. But to that, the Constitutional Court made the point, and we quote them at page 179 of our heads, that the fact that there might often be cogent reasons for holding of joint trials does of course not mean that a specific trial would be unfair, because other possible perpetrators are not charged together with the accused. While it is possible that a particular accused is disadvantaged by the fact that someone else is not charged in the same trial, this does not render the trial unfair. In conclusion, the proposition cannot be upheld that the failure to charge another party who may be suspected of being involved in the same offence in the same trial together with the accused amounts to a breach of any established rules of criminal procedure, and thus to an irregularity of the kind that would result without more in a failure of justice, render a trial unfair and require the conviction to be set aside on appeal. In other words, an accused doesn't have a right to have his trial designed to his best advantage. It is for the prosecution to decide whom to charge together and whom to charge separately, and there is no inherent right in an accused to have the combination designed to maximize the benefit to him. So we submit with respect that the decision of Mr. Ngcuka was entirely lawful, even if one might disagree with the decision and the way it was implemented. I may deal briefly with Mr. Picoli's decision. There can't really be any criticism of Mr. Picoli's evidence, except on one point that there is criticism, and I'll deal with it briefly. But we make the point in our heads that I had earlier made, that after the damning findings are in the Shaykh case, findings of the trial court, His Lordship Mr. Squires, the SCA and the Concord, that a prosecutor would have been remiss not to prosecute. There was a compelling case that had stood the test of fire in 3 different courts and had been overwhelmingly upheld. So there was certainly a good cause for prosecution. The only criticism made of Mr. Picoli is that he jumped the gun. They said he should have delayed his announcement of the decision. He announced it in June, at a time when they already intended to have further search warrants issued and searches done. And it is said he should have delayed that decision until after the search warrants had been completed. But again, that's a question of discretion. Mr. Picoli explains why he exercised that discretion. We quote the explanation at page 183 of our heads of argument. And again, what one must say of Mr. Picoli's decision is that it is a discretionary decision, and he exercised it reasonably, whether we agree with him or not. And what we must bear in mind, remember the circumstances in which he took that decision, and that is that the Shaykh judgments are delivered in June with this devastating indictment of not only of Mr. Shaykh but also of Mr. Zuma. Within days thereafter, the President Mbeki announces that his dismissal of Mr. Zuma as Deputy President, so there is that immediate executive response to that judgment. And public interest is now abuzz. Will he be prosecuted? There sits Mr. Picoli, and he says, because there was such a high public interest in knowing what will happen, I decided to make the announcement. We say today he should have kept the public in suspense for many months, as it turned out for 3 years, until after the search warrant litigation had been over. Well, that's a difference of opinion. It was Mr. Picoli's call. He exercised it. He exercised it in good faith and for good reason. And it is irrelevant whether we think today, with the benefit of hindsight, that we would have taken a different decision. So we submit that his decision too is entirely lawful. Then there is Mr. Mshe's decision. Now, this is an odd attack made by Mr. Zuma, because he refers to Mr. Mshe's decision in April 2009 when he withdrew the charges against Mr. Zuma. But he does not criticize that decision. What he says is that the contemporaneous statement made by Mr. Mshe, his explanation for the withdrawal of the charges, constitutes evidence of the unlawfulness of Mr. Mshe's original decision to prosecute Mr. Zuma. So he invokes Mr. Mshe's withdrawal statement, not because he criticizes the withdrawal, but as evidence of the unlawfulness of the Mshe decision to prosecute. But that, with respect, is a non sequitur, because Mr. Shaykh has already conceded Mr. Zuma conceded in the SCA that Mr. Shaykh's reasoning was irrational. Mr. Mshe's reasoning was irrational. The SCA held that Mr. Mshe's reasoning was irrational. So that irrational justification of his decision can't now be invoked in justification of anything. The effect of both the concession by Mr. Zuma and the judgment of the SCA is to say that Mr. Mshe was wrong to conclude that his prosecution decision had been infected by irregularity. That decision was perfectly valid, so that it destroyed the Mshe withdrawal statement for whatever probative value it might otherwise have had. And let me also just briefly comment on an argument raised by my learned friend Mr. Masuku based on the public lecture that I gave. Now, as I understand him, they don't criticize me for giving the lecture, and I mustn't be understood to defend my own conduct. I don't do so, and I don't comment on it at all. But what he seemed to say in his submission, referring to that lecture, is that the tenor of the lecture was to condemn the NPA for the unlawful conduct of Mr. Mshe, i.e. the unlawful withdrawal of the charges. And therefore, said Mr. Masuku, it establishes that the NPA acted unlawfully and therefore in breach of Mr. Zuma's constitutional rights. But that, with respect, is the same non sequitur, because it is true that the lecture condemned the withdrawal of the charges as being irrational. Mr. Zuma has since then conceded that it was irrational, and the SCA has held it to be irrational. But it doesn't mean that Mr. Zuma's rights were violated at all. Mr. Mshe succumbed to Mr. Zuma's representations. He did exactly what Mr. Zuma's side asked him to do. So there was no violation of Mr. Zuma's rights. There may well have been a violation of his duties, of the duties of his office. There may have been a violation of his duty to the public. But there was no violation of Mr. Zuma's rights. So to suggest that the irrationality of Mr. Mshe's decision in any way impinged upon Mr. Zuma's rights is, with respect, quite unfounded. There is, lastly, the Browse-Mole report. Now, I don't know, well, the spy tapes, but I've dealt with them, and then there's the Browse-Mole investigation. Browse-Mole investigation is a red herring. It's got absolutely nothing to do with this case. Its high water mark is to suggest that there was somebody in the Scorpions who had it in for Mr. Zuma. That's the high water mark of it. But it's got nothing to do with this case. And Mr. Piccoli explains how he responded to the Browse-Mole investigation, and with respect, responded absolutely properly. He saw it, he didn't think it was unlawful, he didn't think it had any credibility, and he put a stop to it. And that was the end of it. But it never had any impact whatsoever on the decision-making process as far as this case is concerned. May I then go to the chapter in our heads of argument on Mr. Zuma's complaint of delay. We deal with it from page 204 of our heads. And may I just preface it with a few principles that need to guide one in the assessment of this complaint. The first is that an accused cannot complain if he was to blame for the delay. The Constitutional Court made that clear in Saunderson, paragraph 33. And we would submit that it means not only that an accused cannot complain about a delay of which he was the sole cause, it also means an accused cannot complain of a delay in which he was complicit, in other words, in which he participated. Secondly, there is the ultimate test for a stay, and you will recall that the inquiry into an application for a stay is firstly whether there was an unreasonable delay. And to determine whether the delay is unreasonable, one does a balancing test, bringing all sorts of factors into play. But if one concludes that there was an unreasonable delay, the inquiry turns to remedy. And the remedy of stay is an exceptional remedy, rarely justified. Justified only if there is trial prejudice or in the most unusual of circumstances. Now, and then on the question of trial prejudice, the requirement is that there must be real trial prejudice, not speculative trial prejudice. And may I refer in this regard to the Botma case at paragraph 35, where His Lordship, where Justice Sachs in the Constitutional Court said of the test for delay, said the delay must be evaluated not as the foundation of a right to be tried without unreasonable delay, but as an element in determining whether the delay will inevitably and irremediably taint the overall substantive fairness of the trial if it were to continue. And I emphasize inevitably and irremediably. He says delay only if the delay will inevitably and irremediably taint the overall substantive fairness. And what he explains those words to mean is this, that the trial, only in the trial will the trial court be able to determine whether there is actual prejudice. So if you're having this debate before the trial takes place, you must ask yourself, will this prejudice be inevitable? Because if it is not inevitable, if it might never happen, then you leave it to the trial court to determine whether there will be prejudice. So that's the requirement of inevitability. If it won't be inevitable, if it may or may not happen, you leave it to the trial court to assess. Secondly, it must be irremediable. He accepts that even if evidence is lost, for instance, that there is trial prejudice, but he says that that is not enough if it is remediable, if there are ways of compensating for the loss of the evidence. So the mere fact that there is evidence might have been lost, and therefore that there might be trial prejudice. If the trial prejudice is capable of remedy, then you also don't grant a stay. And in both those circumstances, you would refuse the stay because you would say that firstly the trial court is best placed to determine whether there is prejudice, and if so, whether there is a way of compensating for it. And our courts have held in this context that vague complaints of loss of memory is not enough. I may give you two references. That's Zanner, paragraphs 16 and 20, and McCarthy, paragraph 47. And then lastly, on the principles, one must bear in mind that there is the countervailing consideration that must always be balanced against the interests of the accused, and that is the profound public interest in the prosecution of serious crime. That is Botma, paragraphs 41 and 44, and Zanner, paragraph 21. If I may then deal with the facts of delay in relation to Mr. Zuma, there is firstly the delay caused by Mr. Nguta's decision not to prosecute Mr. Zuma. And to determine the extent of that delay, there might be two ways of looking at it. there is firstly one can firstly ask yourself, what has been the delay in the institution of the prosecution? In other words, delay in the decision to prosecute. Well, Mr. Muka announced in August 2003 his decision not to prosecute, and Mr. Picoli announced in June 2003 a decision to prosecute. So 2005, you're quite right, 2005. So at least if on that measure of delay, the delay was one from August 2003 to June 2005, and that is a period of 22 months, during which there was the run-up to the Shaykh trial and the Shaykh trial itself. Those were the events in that period. So that's the one way of looking at it. There is another way of looking at it, and that is to ask yourself, what was the delay in the trial date? What would the trial date have been, the commencement of trial, and what would the trial date have been as a result of the delay? Well, the Shaykh trial commenced in October 2004. The delay in the institution of the action would have culminated in a trial commencing in July 2006. There were then other factors that caused the delay of that trial. But the commencement of the trial due to the Muka decision is a delay from October 2004 to July 2006. That is again about 22 months. So it seems that however one looks at it, the Muka decision not to prosecute Mr. Zuma in the first place brought about a delay of 22 months. Remember, we submit a perfectly lawful and understandable decision, but nonetheless one that caused delay. Then there was a delay after Mr. Picoli's decision to charge him in June 2005. But we submit with respect that that delay was brought about in the first place by the search warrant litigation, and thereafter by the rest of the litigation that together made up the Zuma Stalingrad defense over a period of almost 14 years. And we submit with respect that there was no delay after Mr. Picoli's decision about which Mr. Zuma can complain, because he was either the cause or complicit in all of the causes of delay after that date. I turn to the question of harm to Mr. Zuma as a result of delay. Well, factors are the following. Firstly, the first interest protected by the right to a retrial within a reasonable time is the interest of liberty, against the risk of incarceration. Well, of course, Mr. Zuma was never incarcerated, so he never suffered that harm. Secondly, is the harm of the reputational harm caused by the delay. Now, I have no doubt that Mr. Zuma suffered severe reputational harm as a result of the prosecution. But that is not the point. The question is not whether the prosecution has caused him to suffer reputational harm. The question is whether the delay has caused him to suffer greater reputational harm than he would otherwise have done. And with the greatest of respect, there doesn't seem to be any greater reputational harm that he suffered as a result of the delay. And it is important to recognize that the reputational harm he suffered was reputational harm he would have suffered anyway, whether the trial was delayed or not. Severe reputational harm. And it cannot be said that it's...
Can that be really true, Mr. Tringle? Because bear in mind the submissions that were made about the... And I follow your argument regarding the earlier prosecution with Shaykh and all. But the stigmatization existed for a long period and surely that is part of the consideration in the balancing act as to whether that delay caused any prejudice.
But my lady, he would have suffered that reputational harm even if he was never prosecuted.
True, but here, if one considers the facts, one has the announcement by Mr. Nunca, and then one has to look at from that day onwards. Remember, there were also submissions made that the investigation was done in a clandestine manner without legal basis, and then, of course, his reputation was tarnished. So that in itself existed then from 2003 when the announcement was made until today in 2019.
But it is a product of his association with Mr. Shaykh. Let me say, the so-called clandestine investigation, it's absolutely made clear that it was for his benefit and not for any other reason that they tried to keep his name out of the papers. But be that as it may, we must ask ourselves, what reputational harm would he have suffered even if he was never prosecuted? And I submit with respect that the reputational harm would have been severe, because particularly his connection to Mr. Shaykh and the devastating judgments of the High Court, the SCA and the Constitutional Court. So, and that reputational harm is a product of the prosecution of Mr. Shaykh. It's not a product of the delay in the prosecution of Mr. Zuma. You must then ask yourself, well, how much greater reputational harm has he suffered as a result of the delay in his own prosecution? I submit none. He suffers the vulnerability of important celebrities with a high profile. They suffer, other accused might suffer reputational harm only when they are actually prosecuted, and then a delay in the prosecution may prolong that reputational harm. But in the case of Mr. Zuma, the reputational harm was devastating and overwhelming, even if he were never prosecuted. It's not a function of delay, it's a function of his association with Mr. Shaykh. And then, frankly, let us also not exaggerate the reputational harm. The fact of the matter is that Mr. Zuma's public career flourished during this period. He continued to serve as deputy president until after the conviction of Mr. Shaykh. He was dismissed from cabinet after the Shaykh judgment, but because of the Shaykh judgment, not because of any delay in his own prosecution. And in December 2007, while still living under this cloud, he ousted the then President Mbeki as president of the ANC, and he was elected president of South Africa in May 2009. So much for reputational harm. The last consideration is that the case against Mr. Zuma is a very serious and a strong case. I submit lastly that there is no trial prejudice. Mr. Zuma says that he cannot remember the meetings in which he is alleged to have been involved. But the question is not merely whether his memory, that is firstly just a vague complaint of lack of memory. But the question also is not whether his memory today is poor. The question is whether it would have been better if his prosecution had not been delayed beyond a reasonable period. I don't know what he says by when he ought to have been prosecuted. In other words, when a reasonable period ran out. But what he doesn't do is to say, my memory would then have been better than it is today. Assume for the moment that the trial delay for which the state is responsible is 2 or 3 or 5 years. Then one has to ask yourself, would he have been better off if this trial had taken place 5 years ago, or even 10 years ago? Would he then have been better off? He doesn't say, my memory and my evidence would then have been better. And in fact, if you take the one crucial meeting, the meeting with Mr. Tattard in Durban on the 11th of March 2000. That's the encrypted fax meeting. That is the one at which Mr. Zuma is accused of agreeing to be paid a bribe by Thales. Now, Mr. Zuma has gone on record denying that he ever attended such a meeting. He did so, you'll remember that in the investigation, the Scorpions asked him 35 questions, and he replied to those questions. His answer is in the Zuma papers at page 3237, and he deals with the Tatard meeting in two places, in 3249, paragraph 40, and 3263, paragraph 78. If I might just, it's very brief, let me just read you what he says about that. He says at page 3249, this is now, remember, it's an affidavit made on the 13th of August 2003, so that is even before the Nguka decision. He says at page 40, at page 3249, paragraph 40, speaking of the facts, I have only seen a copy of an alleged translation of the facts into English. I have never had a private meeting with Mr. Tatard on the date alleged, namely 11 March 2000. And then later, at 3263, paragraph 78, where it says under the heading Meetings with Representatives of Thomson Thales Group in Durban, 11 March 2000, he says about it, I did not attend such a meeting. So he already denied in 2003 that he attended such a meeting, which means one of two things. Firstly, that it was true, that there never was such a meeting, and that he denies accordingly. But his capacity to deny it is no greater then than it is now, because he has written record of his denial. It may also be that he had by then forgotten about the meeting, but then his loss of memory occurred before 2003. He's no worse off today than he was then. So, with respect, on the crucial issue, he can't plead loss of memory. May I lastly say, as far as Mr. Zuma's stay application is concerned, a point that I referred to earlier, and that is the important rule of law implications in your determination of this case. There is a high risk if Mr. Zuma escapes prosecution that he will be seen to have received special treatment because he is an important and a powerful man. He's accused of corruption, racketeering, money laundering, and fraud in high public office. He managed to avoid prosecution while in the highest public office. He managed to do so by using to the hilt the constitutional legal system available to him at public expense of between 16 and 32 million rands. As a result of his exercise of those rights, the trial was delayed. We submit that there is a high risk that if his trial were now finally stopped, that it would be seen and understood as a final victory of a powerful man exploiting to the hilt the options available to him to delay, resulting ultimately in an undue delay of his prosecution. It is important for the maintenance of the rule of law that all people be seen to be treated equally. And it is important for that reason that Mr. Zuma too is not only treated equally, but is seen to be treated in the way that everybody else would have been. I then turn the last chapter that I will address to page 230 of our heads of argument, and that is the Thales review of Mr. Abrams' decision. And I deal in the first place with the NDPP's power to prosecute. Because Thales contends that the NDPP's only power to prosecute is the power vested in him by the National Prosecuting Act by section 29.
22 sub 9.
Yeah, I got the wrong copy of the act. We submit with respect that the NDPP's power to prosecute is in the first place derived from the Constitution. And that even if the NPA Act had never been enacted, that he would have been entitled and had the power to prosecute under Section 179 of the Constitution. And we refer in this regard to the following two provisions of the Constitution. Firstly, Section 179(1), which says there's a single national prosecuting authority structured in terms of an Act of Parliament and consisting of a National Director of Public Prosecutions who is the head of the prosecuting authority and is appointed by the President. And then that must be read with 179(2). It says the prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary function incidental to instituting criminal proceedings. Now, if one were to stop there for a moment, we submit that when those two provisions are read together, then it says that the NPA has the power to institute criminal proceedings. That's the institution, has the power to institute proceedings. And the NDPP is the head of that institution. In other words, he is the highest decision-making organ of that institution, prima facie entitled to exercise any of its powers, except to the extent that his powers to do so are limited. And then the Constitution goes on to give effect to what my learned friend referred to, and that is the history of the negotiation. That's the transition from the old system to the new. My Lady Justice Steyn has written about it, and it's well known to those of us who are old.
When she was young.
But that is this. The Constitution seeks to accommodate a blend of the old system and the new. Under the old system, there were provincial attorneys general who were autonomous in their decision making. That degree of autonomy, by the way, varied over the years, as we know, but in principle, autonomous. Under the new system, a new NDPP is created, which sits at the apex of the NPA. And what the Constitution then does, we submit, is not to bleed the NDPP dry and vest all the powers in the provincial DPPs. But what it does is to recognize him at the head of that organization as the apex authority of the organization, but then to guarantee limited autonomy of the DPPs. And the autonomy they are given autonomy by two means. The first is to say that they have responsibility for the prosecutions in their district, in their region. Responsibility doesn't mean they're an exclusive power to prosecute. It means that they are accountable for the prosecutions in their region. The second is to restrict the NDPP's power to interfere with their decision making. So the provisions that follow, and I'm going to go to them in detail now, but those provisions are provisions which are designed to reinforce the limited autonomy of the DPPs by restricting the NDPP's power to interfere with them. Now, what our learned friends do is they look only at the second category of provision.
They see the scenario that they painted was to give the power with your left hand and take it away at the same time with your right hand. That's the interpretation.
Exactly, my lord. What they look with blinkers on only at those provisions that say that his power to interfere with the DPPs is a limited power. But then they equate that with the powers of the NDPP as if those are his only powers. And that is with respect where they make a mistake. They leave out of account that that's the second level of provision. The first level is one that says he's the head of the organization and therefore he can exercise all its powers on its behalf. The part where limited autonomy is granted to DPPs is merely a derogation from the overall power, a limitation of that overall power to say, but you only have your power to interfere with the DPPs is limited, and it may only be exercised in certain ways and in certain circumstances. And once it is seen in that way, namely that he has, the default rule is that he can exercise all its powers. His powers to interfere with DPPs, however, is a limited power. And then there's a third provision that says, but remember, he's not only the head of the organization, he can also prosecute. And we submit that that is what 22.9 ultimately says.
But then the argument was presented to us that if that is the approach, then strictly speaking, section 22 sub 9 is then meaningless. I understood it to be always that it is in addition to all the other powers and not taking away from the general powers in terms of 22.
Yeah. No, Melody, I submit that that is absolutely correct. I submit that it is to make clear that his powers aren't limited to the powers mentioned above, i.e. the powers as head of the organization to take decisions on its behalf. In addition to those powers, this section says, but he can actually personally prosecute if he wants to. So it's an additional power, it's not a limitation of anything. But let me just continue with the Constitution.
Just to avoid embarrassment.
Yeah. My learned friend reminds me, and I apologize, the NDPP is not a man, it's a woman. So I mistakenly referred to the abstract NDPP, but the real NDPP is a woman. As far as the Constitution is concerned, I've read the first and the second subsections. Those are what I call the default provisions. That says these are the powers of the NPA, and the head of the NPA is the NDPP. In other words, he can exercise all of its powers on its behalf. And then it confers limited autonomy on the DPPs, and it does so by the following provisions. It says in sub 3, that's 179 sub 3, national legislation must ensure that the DPPs are responsible for prosecutions in specific jurisdictions, subject to 5. And we say in our heads of argument that when it says responsible, it doesn't mean have the exclusive right to prosecute. His Lordship, Mr. Justice Harams, interpreted that word in the Audi case, and he said responsible there means we say in a paragraph 551 in the Harams judgment, the SCA no. Let me come back to it shortly.
552.
Paragraph
555.
Oh yes. No.
555.
No, it's not.
It's in 551.1.
Oh yes.
On 232.
Yes, he said that responsible there means that they are accountable for those prosecutions, not that they have an exclusive right to it. And then, so they must be given the power to prosecute in their regions, but that is subject to sub 5. And sub 5 is then the NDPP's limited power of interference, and particularly C and D may intervene in the prosecution process when policy directives are not complied with, and may review decisions of prosecutors, but then prescribes the process by which it is done. So, but what those provisions do, they do not purport to be the definition of the powers of the NDPP. They are merely the provisions, the second level of provision after the default rule, by which limited autonomy is granted to the DPPs, and the NDPP's power to interfere with them is circumscribed. Now that is the Constitution. If one then comes to the NPA Act, then we submit that Section 22(1) gives effect to what I've called the default rule of Section 179. It says the National Director, as head of the prosecuting authority, shall have authority over the exercising of all the powers and the performance of all the duties and functions conferred or imposed or assigned to any member of the prosecuting authority by the Constitution, this Act, or any other law. So that merely articulates what I've submitted is already the default rule under the Constitution. So if you ask under what law does the NDPP have the power to prosecute, then it is in the first place under 179(2), but that must be read with 22(1). But the two of them together regulate the same power. It's not two different powers. It is the self-same power. And that is important when I get to my learned friend Mr. Katz's suggestion that when Mr. Abrams said, I acted under 179(2), he made a mistake because he really acted under 22(1). It's the self-same power. It has its origin in the Constitution, and it is confirmed in the Act. And then the Act also goes on to regulate the NDPP's power to interfere with the DPPs, as we've previously said. And it comes in sub 9 and says, but apart from anything else, he may also prosecute in person. So we submit with respect that his power to prosecute lies in the first place in section 179(2), read with 22(1). They are the self-same power. They are not, he is not limited to a personal prosecution. His Lordship presiding also made the point of the absurdity of saying that his only power to prosecute is if he does it himself, that he's not allowed to decide that someone should be prosecuted and then to tell Billy Downer to do it. That he may not do. He may only do it if he does it himself. And such a rule is with respect, so absurd that you would never be persuaded to adopt it. And then my learned friend Mr. Katz said that Mr. Abrams' decision was unlawful because he only invoked section 179(2) and therefore cannot rely on 22(1) of the Act. He invoked the wrong section. But as I've said, his power is a power in the first place derived from 179.2. That is what the Haram's judgment held, that is where the NDPP derives his power to prosecute. That power is further expressed in 22.1, but it's the self-same power. And it doesn't matter whether the NDPP says, I acted under 179, or I acted under 22, or I acted under both. He would be right every time, because all three expressions identify the same power. Mr. Katz also says that we contended for the first time that Mr. Abrams had acted under 22.1 in our heads of argument. But that's because Thales did not raise their 22.9 point in their founding affidavit. It's a late point that came only in reply. And so it doesn't, strictly speaking, they shouldn't be allowed to raise it at all. We haven't objected because it's a law point. But for them then to say that we refer for the first time to 22.1 in our heads is, with respect, unfounded. There is second attack on Mr. Abrams is that he acted in breach of the prosecution policy, because it is said that there was insufficient justification for his decision to reinstitute a prosecution against Thales. And with respect to our learned friends, they misconstrue the prosecution policy. The prosecution policy doesn't say that you have to bring yourself within any one of those enumerated examples of special circumstances, exceptional circumstances.
Special reasons.
Special reasons. What it says is there may be special reasons why a prosecutor will review a particular case and restart the prosecution. These include...
Isn't it true that when one looks at the prosecution policy, it is not a limitation of only these specific reasons? It could have said, inter alia, the following may be regarded as special reasons. It's giving guidance to the fact that that when the state does that, when a prosecutor does this, there must be special reasons.
Yeah, indeed.
It is in the same way that courts will go about interpreting substantial and compelling circumstances.
Yeah.
What is understood under special reasons? Yeah.
No, indeed, my lady. And in fact, it also used the language to make that clear. It says, these include. Now, that is very clearly a word that says the following are examples of special circumstances, not an exhaustive list. And we submit in the first place that Mr. Abrams' decision, in fact, falls within the first enumerated bullet point. The first one is an indication that the initial decision was clearly wrong and should not be allowed to stand. Well, the initial decision to withdraw against Thales was a decision made by Mr. Mshe immediately after he had withdrawn the charges against Mr. Zuma, because he believed the prosecution to have been unlawful. Now, and it was only because he thought that he had lawfully withdrawn the charges against Mr. Zuma that Mr. Mshe then also withdrew the charges against Thales. But the premise of the second withdrawal was that the first withdrawal was lawful. By the time Mr. Abrams had to take the decision, the SCA had held and Mr. Zuma had conceded that the Mshe withdrawal decision was unlawful, and it was set aside, and it was invalid. And Mr. Abrams legitimately says to himself, well, so the Thales withdrawal was clearly also a mistake, because it was based on a false premise, and therefore I will reverse it. So one can say that there is an indication that the initial decision to withdraw against Thales was clearly wrong and should not be allowed to stand. But one should also, we submit in the alternative, it's not necessary to strain to bring ourselves within the first bullet point, as I've submitted. Any special reason will do. And clearly in this case, there was special reason to reinstate. The initial withdrawal was based on a misconception of the lawfulness of the Zuma prosecution. It is true that there had been a long delay, but the outcome was that the court had reinstated the Zuma prosecution, and for that reason there were special reasons to reinstate the Thales prosecution as well. Then our learned friend lastly contends that it was procedurally irrational for Mr. Abrams to recharge Thales without affording them a hearing. Now, Mr. Abrams describes the reasons why he failed to do so. If I may just give you the references, it's page 4581, paragraphs 63 to 68, page 4586, paragraphs 80 and 81, and page 4596, paragraph 112. And with respect, what he says is, the starting point, the default rule is that a prosecutor doesn't need to give the accused a hearing before deciding whether to prosecute him or not. The remedies of the accused is, once he's been prosecuted, is to make representations if he wishes, or to have his day in court. But there's no right to be heard before a decision is made to prosecute. In the case of Mr. Zuma, Mr. Abrams did afford him a hearing because Mr. Zuma came forward timelessly, asked whether he could make representations, and Mr. Abrams acceded to his request, considered the representations, and dismissed it. Thales then came along very, very late, many months later, and said, can I also make a representation? Mr. Abrams correctly appreciated that it was undesirable to delay his decision yet further. There was a high public interest. He was under pressure from civil society to make his decision. In fact, there was litigation about whether he should be allowed to make the decision or not, and he had to give notice to KZAC if he made it. So there was a high public interest in getting finality on this issue, and in those circumstances he decided to announce the prosecution without first giving them a hearing. And we submit again with respect that there is nothing irrational about it. Remember, the test here is procedural irrationality. There's no right to procedural fairness. The question you ask yourself, is there some rational connection, some rational basis on which he exercised that discretion? And we submit with respect there clearly was. He received their representations after the event, after he had decided to prosecute them. Of those representations, my learned friend Mr. Katz says that the offer to Thales to receive their representations after the decision to prosecute was ultra vires because he did not have the power to review himself. With respect, that is not so. What he refers to is the judgment in the spy tapes case that says that when he reconsiders his own decision, he doesn't act under 179.5 because that applies only to a review of the decisions of other people. But that doesn't say that he may not reconsider his own decision. He has the power to reconsider his own decision as any prosecutor does. So the suggestion that it was unlawful for him to accede to their request to make representations is with respect unfounded. And then the criticism of him is lastly that he dismissed their representations, but that his dismissal is not rational. On that score, Mr. Abrams took that decision as follows. He firstly had the benefit of the background of the prosecution's team memo on the Zuma representations. That came before the Thales representations. If I may just give you those references. That is at page 4682, where the charges are set out, and page 4703 to 4709, where the memo describes the complicity of Thales in the Zuma charges. Then there was a second memo. My learned friend, Mr. Katz, was mistaken on the score. He said there was no prosecution memo on the Thales charges, but with respect there was. The prosecution memo is dated the 28th of June 2018, and it's at page 4871. Mr. Abrams explains why he decided to dismiss the Thales representations. He does so at page 4591, paragraphs 91 to 94. And one of his main considerations was to say they complain of delay and that has deprived them of a fair trial. I believe that it would be more appropriate for me to persist with the prosecution and let the trial court decide whether there has been undue delay. And with the greatest of respect, that is a lesson that Mr. Shaykh was taught by the spy tapes litigation. Ultimately, one of the compelling reasons why the court overturned Mr. Shaykh's decision is what it said, that you should have left that decision to the courts. So that, again, to criticize Mr. Abrams for his decision taken on the same basis is unfounded. The test, again, is one of rationality. Is there some rational basis for Mr. Abrams' decision? We submit that there manifestly was, and for that reason, that his decision cannot be reviewed. Even if, yes, that leaves only our submissions on the Thales delay complaint, and my learned friend, Mr. Breitenbach, will make those submissions. I see, though, that it is lunchtime, my lord.
No, I think we can adjourn. We can adjourn. It's like 4 minutes. Because we usually come for the past few, but we at 2.
Come back at 2. We're trying to see whether we can start at 1:45 so that you can have more time. But, we're starting at 2. We start at 2.
Thank you.
Good.